A very warm welcome to everyone joining us today for this discussion on mediation in India, recent developments and impact on construction and infrastructure industry. I'm Swara Ghate, lead business development at MRP Advisory, and I shall be your moderator for today's discussion. On this panel, we have Mr. Unmesh Kulkarni. Mr. Unmesh is currently designated as Senior Vice President and also acts as Functional Head for Contracts Administration, Enterprise Management, and Legal with Shapoorji Pallonji Company Pvt. Limited. With over 34 years of experience, Mr. Kulkarni has in-depth experience in managing contracts and disputes for a wide range of projects, including power plants, LNG terminals, tankages, process plants, etc. On the panel, we also have Dr. Mukul Shastry. Dr. Shastry is currently the General Counsel and whole-time Director at Cube Highways. He has more than 2 decades of experience and has been conferred many accolades such as Law Asia Top GC, Legal 500 GC Powerlist 2023, Forbes India Top General Counsel consecutively for the year of 21, 22, and 23, BW Business World Top 100 GC, and much more. And lastly, we have Mr. Nikhil Ramdev. Mr. Ramdev is a senior associate with MRP Advisory, a highly recognized Dubai-based law firm in the list of Legal 500 UAE 2024. With around 8 years of experience, Nikhil has extensively involved in handling complex, high-value international arbitration matters involving disputes worth USD 600 million. Before we delve into the specific, let's briefly acknowledge the growing significance of ADR in today's complex legal landscape. Mediation in particular has emerged as a valuable tool for resolving disputes efficiently and amicably. In the context of construction and infrastructure industry, where disputes are frequent and often complex, understanding the recent developments in Indian mediation law is extremely crucial. To begin, I would like to invite Mr. Ramdev to elaborate on the recent developments in mediation in India. Nikhil, over to you.
Thank you, Swara. Before starting with the recent developments, I'll just briefly tell about the history of mediation in India. So, mediation is deeply rooted in India since time immemorial. Panchayati system prevailed in India, whereby disputes were resolved by a group of village elders. Then, the formal integration of mediation into the Indian legal system can be traced from Industrial Disputes Act 1947, wherein the detailed procedures were prescribed for setting disputes outside the court. Lok adalats were established by Legal Services Authorities Act, which gave further impetus to the mediation concept of mediation in India. Then Section 89 was introduced of CPC was introduced into by way of amendment in 2002, which gave commercial mediation a statutory recognition. The last decade has been a game changing for mediation. I believe we can say that mediation is the new currency in resolving commercial conflicts. India has made many legislative and policy changes in this regard in the last decade, whether it's the enactment of Commercial Courts Act 2015, which provides mandatory pre-institutional mediation in commercial suits. I would like to highlight that the Honorable Supreme Court has said that this provision is not just a procedural requirement, it must be complied with before any remedy can be availed under the Commercial Courts Act. And in any event of failure to invoke pre-institutional arm mediation, a commercial suit may be dismissed. The mediation has also been introduced in Companies Act and Consumer Protection Act as well. So in 2020, India ratified the Singapore Convention on Mediation, and on that basis, Mediation Act was formulated. So one of the key features of the Mediation Act 2023 is the enforcement of mediated settlement agreement. The Mediation Act states that the mediated settlement agreements are final and binding on the parties, and they shall be enforced as if it were a judgment or decree passed by the court. So it also provides interim relief as well, provisions for interim relief. So the long-standing issue with mediation's non-enforceable nature has been taken care in the Mediation Act. On the policy front, the Government of India has, in recently, Ministry of Finance issued guidelines for arbitration and mediation in contracts for domestic public procurement, where they propose mediation as an alternative arbitration in procurement contract disputes, proposed limiting arbitration under 10 crore dispute value. Further, the Karnataka government recently issued a circular stating that the compulsory arbitration clause is withdrawn from the state tenders and contract, which I believe will certainly lead to rise in more other alternate dispute method resolution than ADR. Thank you.
Well, thank you so much, Nikhil, for such insights. I would actually like to take this discussion to Mr. Kulkarni. Mr. Kulkarni, following that insight, given the fact that Shapoorji is heavily invested in Indian infrastructure story, how do you believe that mediation and arbitration has played a role in resolving the conflicts in the industry?
See, mediation has played a significant role in resolving the disputes, being an informal channel of interaction and guided negotiation. Mediation is nothing but a guided negotiation, where probably an expert or a person who have a slightly better understanding is trying to come in and handholding the parties to resolve their issue. Because what happens is majority of the time in era of some other aspect, one has to initiate his trigger the dispute resolution process, and then probably one has to just sit back and see that whether I have an opportunity to resolve this before we actually land into the process of arbitration or subsequent legal aspects of it. Though there are we are also member of CFI, and on the Ministry of Expenditure IOM on this limiting arbitration to 10 crore is viable or non-viable. There is a separate discussion happening, and which is a point of big debate, because in the infrastructure segment as well as in the construction development, dispute of 10 crore is a peanut. So majority of the dispute, or rather all the disputes, will be about 10 crore. So whether practically mediation is a solution, answer may not be no. But yes, mediation can play a role subject to the government side of the organizations take that seriously and create SOPs to authorize people who are appearing in the mediation. The challenge that we are experiencing today is wherever now the mediation is being proposed in lieu of even DRC, which is the first step of dispute resolution. But then the participation from the other side is not that highly appreciated, and the support is not been extended.
Got
Over
it,
to you,
sir.
Swara.
Right, brilliant, brilliant. Thank you for sharing that insight, sir. I want to ask, Dr. Shastri, given the recent policy shifts favoring mediation over arbitration in construction, how has this impacted your company's approach to risk management and dispute resolution in your Indian toll road investments? Are your investors worried or favor with the approach of the government?
So thanks, Swara, and first of all, thanks for having me. And I'll just take a cue from what Mr. Unmesh has rightly said. That, see, infrastructure disputes are complex disputes. There's hardly any dispute which is of 10 CR. It is always in hundreds of CRs. And not only the quantum of money, but the issues at times are very techno-legal issues, which generally only an expert can understand, who understand those technical nuances. Now, in this case, yes, investors are worried. So obviously, we have signed mediation, and mediation may be a solution. Only time will tell. But the only problem is we have to really address the intent. Like, see, we wanted India to become an arbitration hub. The Arbitration Act, the latest one came in 1996. Earlier one was 1940, but then we came with the unilateral model 1996. It has worked for almost 30 years till now. But is India arbitration hub today? Still you see more than 25% of arbitration cases are pending for more than 10 years. So is arbitration failed here? And why arbitration has failed? Because it is the intent of parties. In infrastructure, in most of the cases, you will find one of the parties, the government, or one of the litigant is government. And therefore, it is incumbent on at least government to ensure that these things do not happen. Why is the delay from government side? Why they don't appoint arbitrators on time? So the problem is, it is just the intent of just taking whatever it may be, whether it's arbitration or mediation, take it seriously and do it. If the intent is not right, unfortunately, mediation will act nothing, but merely a delaying the entire thing by 180 days more. So if it is 10 years delay, it is now 10 years, 6 months delay, because it's 180 days mediation is the minimum mediation time that is generally there. So the problem is all about intent. So if the intent is right, I feel mediation will definitely work. If you have really good mediators who can really guide the negotiations well and can tell the party that this is the real strength of your case and this is what the case is, it will definitely work. But if that is not the case, we have seen from the arbitration example, if that intent is not there, and especially the intent is not there with the government has to really push it with all corners. Maybe then that this will work well. The dispute solution system will work well. So we have to really work on arbitration, we really work on mediation. So that is basically, and the intent corporate sector should also be there. So it is both ways, but primarily government has to take more initiative because government is the largest litigator in most of the cases. And again, Mr. Unmesh has taken one very interesting point he was alluding to. He's saying, see, the problem is that mediation may or may not be there, but the point is why, or if it has been successful, what is the most important thing is the guided negotiation. And this means the person who's negotiating it, the mediator himself or herself, that person should be skilled enough to take it through and ensuring that you come to a point where both the parties agree that, okay, let's just take this solution, and which is a win-win solution, or it is a solution which has to be taken. So that is one thing which has to be seen how we develop. Until unless that doesn't happen, whether it is Indian investors or foreign investors, we obviously will have our skepticism, and that is still there. Unfortunately, despite the act being there passed in 2023, I will say that skepticism is still there. Over to you, Swara.
Such brilliant thoughts, I must say. I actually have this observation wherein Nikhil mentioned about the Karnataka stand. I have a follow-up question from Nikhil on this one. Nikhil, you've highlighted the significant development of the Karnataka government removing arbitration clauses from its contracts. I would want you to elaborate on this and its broader implications for the Indian legal landscape and the industry.
So the step certainly puts a big question mark on making India as a preferred seat of arbitration. The implication would be that such dispute would be resolved through courts which are already overburdened and it's time consuming. Though on the plus side, it might lead to increase in the court annex mediations, including pre-litigation mediation. For the ease of doing business and enforcement of contracts, speedy disposal of disputes is necessary, which can be done through ADR, not courts. So it is imminent that certain clarity is given to the business community and action is taken for ease of doing business. So what do you say?
Thank you. Thank you for that. Mr. Kulkarni, with the latest trend of mediation as the preferred tool to resolve conflicts, how are you adapting to the new policy, you being Shapoorji Pallonji?
See, as I said in my earlier answer also, that we are very adaptive, we are positive about it, because ultimately money that I get today as a part of my outstanding is better to have today than having 5 years, 7 years, or 10 years down the line. Nikhil has just touched on the Karnataka government regulation. As one of the risk appetite or risk management profile when we look at any tender, no arbitration clause or no DRC process except the court is sometimes become a big risk alarming point, even when the tender has been assessed for whether to bid or not to bid, because then the issue of evaluation of the client's intent, like what Mukul has rightly said, is also being surveyed before even the tender is floated. Of course, now I'm coming back to your specific question. If you look at for the transaction, when we represent us as a contractor, we have two streams. One is upstream, that is towards client, and one is downstream, which is towards our vendors and subcontractors. Now courts are also started implementing mediation as a first tool of settlement. When we have many downstream matters, we are being advised by the high courts to explore mediation, and we are positively looking into that, and we are seeing the results are coming out. Because like I said, with trigger of something, either side of the party initiate the process of dispute resolution, maybe arbitration or maybe recovery suit or maybe any other forum. MSME, which is another virtue which has recently come up and which impacting everyone. Now there can be an issue, there cannot be an issue, and those forums have a limited jurisdiction. So all aspects are not being seen there from a holistic perspective of a issue raised. Its only issue in front of them is non-receipt of payment. Whereas when the matter is referred to mediation, those aspects are being dealt with and the effective resolutions are being reached. Okay, that's on downstream. So there's on the downstream, there is a certainly a positive impact of this mediation. We are able to save huge amount of litigation cost or dispute resolution cost, and also the either parties are continuing their relationship, because in India we still work on the emotional quotient, not on totally the professional quotient. Okay, now when I come to the upstream, the challenge continues. Even if I have a good amount of examples wherein, in spite of you being directed by the court to undergo a mediation, the non-cooperative approach of the government litigants are forcing the mediators to cancel the mediation process and respond to the court that mediation has failed. Also, another good example is, in the mediation, what is expected, since this is a guided negotiation, you need the people who can make the decision in the process of deliberation and discussion and assessment. Now, one of the bigger challenge we have observed is, the representative who come from the other side of the litigants, which are largely the private government entities, are not empowered to take any decision. So what is going to happen by virtue of that is the mediation is going to get failed. So I again reiterate that unless and until the DOP for the mediation is being categorically driven separately with the empowerment to the concerned government authorized representative, the mediation is an excellent tool, but may not give an effective and efficient results.
Understood, sir. Crystal clear. Thank you for such thoughts. I want to take this question to Dr. Shastri. What kind of challenges you generally face in your sector in relation to dispute resolution? Specifically, why most of the foreign investor prefer SIAC or such outside destination even for arbitrations that are concerning or relating to Indian enterprises?
Very interesting question, Swara. And I guess most of the infra companies, especially the foreign funds and even the domestic funds, are talking about it. That why should we force on SIAC? And especially when we have, as Mr. Unmesh said, that when we have clients like Shapoorji Pallonji who are our clients, suppose we got a contract and now we want Shapoorji Pallonji as an EPC player, then they will object that why have you had an SIAC clause when we're a domestic player, we are working in India, why you want an SIAC clause in your EPC contract? And then we have tough time negotiating with people like Mr. Unmesh sir and convincing them that no, this is a no-go for us and we want only SIAC. Now, why? The logic is very simple here. See, in India, unfortunately, fortunately, arbitration somehow has never settled. See, what you need in a dispute resolution, you need basically three things. First is the expedition, the fastness, the process has to be quick. So that is the expeditious disposal of matter. Second is the certainty of matter. Okay, that if this is what it is, then this is what you will get. The certainty of legal principles. We keep on changing, tinkering things at times, and therefore the certainty, what is arbitrable, what is not arbitrable, that still at times becomes complex in the country. So that certainty has to be there in law. Now in Section 36, we have added fraud and corruption as a new exception for getting stay. Now, what is fraud, what is corruption cannot be decided in one hearing. It is a matter of fact, and a question of fact, it takes a lot of time to deliberate. So those kind of things makes things uncertain. Public policy otherwise itself is a very, very unruly horse where it will take you, no one knows. So Section 34, Section 36, that certainty is missing. So not only it is expeditious, not only it is certain, and third is the ultimate enforceability of, if you get something, ultimately want the color of the money. I do not want only a paper degree. I want ultimately the money coming today, and as fast as the money comes, it is better. And therefore we see the schemes like Vivad Se Vishwas. Now what that scheme is, that if you have the arbitration award in your favor, you will take a 35% haircut on the net amount, and you can get the money from government. If you got it even approved at the Section 34 stage, you will still take a 15% haircut and get your money. This means even the government itself agrees that your enforcement will not happen in time. Better take some haircut and take the money. So that is the problem. So you have to have very quick process. Then second thing is at least you have to have that certainty of decision making. And third is ultimately if your decision has come, then the enforcement of this decision has to be faster. Now, at least the first two in a SIAC arbitration becomes easier. So if I go to SIAC, it is much more easier for me to at least have that info, at least have the initial part faster, at least have the arbitration award faster, say in 12 months' time, 15 months' time, 18 months' time. And second is at least I have the certainty. Okay, if these are the matters, more or less that's how the SIAC is giving decisions. We have all those cases listed there. I can just do a simple search and find out that in such cases, what is the precedent that SIAC has been doing. All these things are reportable. I have a single copy available on a single click to know that, okay, these are the 100 cases that they have decided on this matter, and this is the trend has been. So that kind of certainty is there for me. I can understand, okay, this is where this will lead to. So those things give me that much more comfort in such institutional arbitration. Unfortunately, in India, that trend is not there. We do not have those kind of institutions right now which have come that well, whether it be Delhi or Bombay or Bangalore or Hyderabad. The arbitration centers have not have become that big a name in themselves, unlike SIAC or other foreign centers. Second is, and then the interference of courts also too much into India. Because at every stage, a party who wants to delay the things will definitely go to court, get some kind of stay, get some kind of decision. So therefore, those things we have to really work on. So as I said, and that is why SIAC is a preferred destination. Well, out of those three, at least first two, I can be more clear that at least these two things will be faster there. It will be faster there and more certain there. So that's why SIAC becomes a preferable destination for companies. But then again, we all have to collectively work here. We have the great talent in India. The best part is we have huge talent in lawyers and in arbitrators and people, and therefore we have to leverage that thing well if we really want to make India an arbitration hub. So that is what I feel is the reason.
Right,
What
sir.
do you,
So just following up on
Swara,
that, sir.
Swara, just to supplement
Yeah,
what
please, sir. Please.
Mukul has just said. See, in India, the ad hoc arbitration concept is being prominent over the institutional arbitration. And institutional arbitration have its own advantages. Of course, there are some disadvantages, but there are larger are the advantages over the disadvantages. Vis-a-vis in the ad hoc arbitration, it solely depend upon the presiding arbitrator and method manner in which he want to exercise the arbitration proceedings, though it is under the guidance of Arbitration Act. Now, Arbitration Act doesn't have that stringent rules, regulations that need to be applied with. And also, if we see the concept of Arbitration Act was not to have a quasi court. It's actually supposed to be a very simple method manner in which even the layman can, present himself and get his dispute sorted. Vis-a-vis, if you really see the way the arbitrations are conducted, it is nothing but proceedings under the court, including with due respect to everyone, we say my lord in the arbitration proceedings. And if I'm not a counsel, I'm not allowed to speak in the arbitration in majority of the cases. So why do I need a counsel to represent me if I'm undergoing arbitration? Arbitration Act doesn't require counsel to represent.
Right, sir.
You know,
Actually, we've tried to cover most of it, but I still want you to give your parting thoughts on what your expectation is of dispute resolution in the construction sector. Just in 2 to 3 sentences, if I can have your parting thoughts from all three of you, that'll be great.
okay, I'll start. I'll take
Sure,
a
sir,
liberty
please.
to start.
Please do.
I once again reiterate the powers to the person who is appearing in the mediation. If that happens and if effectively works out, mediation is the best way to go forward because it's economical, faster, and it is dealt by the right person. Possibility of having right person to mediate. So that if these are the 3 triggers, mediation can be the smoothest way to resolve the dispute. Over to you, Mukul.
Yeah. So thanks. So my parting thoughts, see, I come from a private equity fund, so I'll give some kind of a number-centric answer. So if we want India to be a Viksit Bharat by 2047, this is what we all dream and aim for, then the GDP has to grow by almost 9-10% in double digit, 10%, let's say. Right now we are growing at 6%. Now, how to make it grow by 10%? There are many things, but at least what is in our hand, that today infrastructure, I say the problem is no more engineering problem. We have great engineers, great engineering solutions. We don't have finance problem. A lot of people are ready to invest into India because a lot of money is there. India is the vibrant economy right now. China is slowing down. But what is really taking us back or holding us back is the ease of doing business and the enforceability of contracts. Still, we are in our enforceability of contract, we are, I don't know, we are at 162, 163 in that number. We are behind even the lower economies. So that is what holds us back. And why enforcement of contract is so low? Because our dispute resolution is so lengthy. If I today takes 100 rupees of Unmesh sir, and he has to file a case against me, or say 1 lakh rupees, and he has to file a case against me, maybe his grandsons also cannot recover that 1 lakh rupees from my grandsons. So it is that is the problem. So where is the enforceability of a contract here? So that is why we really have to really work harder with our right intent to have this mediation work, make the arbitration work. It's all about our intent collectively of government, of society, of corporate personalities. So that is what I will leave away with this parting thoughts. Thanks for having me.
Thank you, sir. Nikhil, over to you.
I believe India should focus on making itself as a preferred series of mediation, not just arbitration. And it is high time that Mediation Act should be made operational in full, and necessary amendments should be made so that it becomes more appealing for cross-border mediation settlements as well. Thank you, sir.
Thank you. So, I believe this discussion has highlighted the crucial role of mediation as an effective and efficient tool in the construction and infrastructure industry specifically. And with this, I, on behalf of MRP, would really extend heartfelt, sincere thanks to all the three panelists, Dr. Mukul, Mr. Kulkarni, and Nikhil for joining us on this session. I would love to stay connected and hopefully see you soon. Thank you.
Thank you very much. Thank you,
Bye-bye.
Swara. Thank you. Take care, guys. Bye.